Greetings, everyone, and welcome to the OFCCP Institute's web chat. I'm David Cohen. I'm joined by my co-chairs, Mickey Silverman, and the third co-chair, David Fortney. And we thought we'd talk to you today about the most recent Supreme Court ruling in the Fisher versus University of Texas. Fascinating ruling as it relates to affirmative action. We'll get to that in a second, but first just tell you who we are and a little bit about us. So we are here today as the OFCCP Institute, a nonprofit membership organization based in Washington, D.C. And like I said, we are a membership organization. We provide educational services in terms of training, webinars, things like that. We also offer membership. And we are building out our membership as of now. If you're interested in becoming a member of the Institute, check out our website at theofccpinstitute.org. We are not affiliated with the U.S. Department of Labor's OFCCP. We are a separate nonprofit organization. Not only do we provide educational services, we also like to give back to the community. So one of the things, if you go to our website, in honor of the 50th anniversary, which happened in September, we put together a historical video that will be housed at the Civil Rights Museum in Memphis. And if you haven't seen the video, take time to look at it. We gathered majority of the former OFCCP directors, and just to bring them together and get the history of Executive Order 11246 on a video, and it's absolutely fascinating. In addition to that, last week we are really happy to announce that we awarded 4 scholarships to DC public students in the amount of $40,000, $10,000 each. We had a luncheon with the students and their families and friends, and it was just really great to meet these young and ambitious kids and hear about what they're doing and what schools they're going to and what they're going to be studying. And we hope to make that an annual event. So we're really happy about the scholarship program. And if you're interested in being a donor for our scholarship foundation, please reach out to one of the co-chairs. With that being said, gentlemen, my 2 lawyers, tell me about this Fisher ruling and what it means for affirmative action in the United States. David, why don't you kick it off and tell me what happened?
Sure, I'll be happy to jump on that. So on June 23, in a much anticipated ruling on affirmative action, the Supreme Court handed down its decision in Fisher versus University of Texas. Those that have been following this will remember this is actually the court's second time that it has ruled on the University of Texas affirmative action program. In this decision, there was a 4-3 ruling upholding the University of Texas's affirmative action program, so 4-3. The key vote was Justice Kennedy, who authored the majority opinion. The dissent, in which the Chief Justice, John Roberts, Justice Thomas, and Justice Alito, was very strongly worded, with Justice Alito authoring a 50-page dissent. Really scathing on the reasoning and rationale and conclusions reached by Justice Kennedy. In Justice Kennedy's decision, so it's important because all of us on this call, on the webinar, are in the private sector. The case involves public sector state universities. And the reason that's important is that legally there are slightly different standards that the Constitution applies in that it has to survive what's called strict scrutiny. In this decision, Justice Kennedy ultimately rules that the Texas program that took into account your academic performance, top 10%, as well as additional factors that they did, sort of this holistic examination of the file in which race was included as a consideration. And that was a key point for the dissenters. But ultimately, Justice Scalia said, look, in the nation's education system, it is always difficult to, as he described it, reconcile the pursuit of diversity, which is recognized as a very important legitimate objective, the pursuit of diversity, with the constitutional promise of equal treatment and dignity. In this case, the claim was that a white applicant, Fisher, was denied her admission to the university because the diversity program resulted in non-whites being admitted instead of her. So that was the ruling. That's the dissent. It has some pretty strong language in it, and I think, Mick, we should talk a little bit about kind of what it means for federal contractors.
Hey, and Mickey, before you do that, David, let me ask you a quick question, then pass it to Mickey to give me his take. Kagan recused herself, right, from the case. So, in theory, tell me if I got this right. If she didn't recuse herself, it really would have been 5-3. So even if depending upon the election, you get a conservative judge, it's probably going to go 5-4 in the future, right?
Probably right. Justice Kagan, I mean, she hasn't authored an opinion yet addressing affirmative action, but I think that's a safe assumption. So under your scenario, if President Trump wins the election, he makes a Supreme Court appointee, presumably that justice would side with the dissent. So you're right. We likely end up still with a 5-4, very closely divided split, frankly, probably largely representing much of America on these issues, but with the court ultimately coming down in supporting affirmative action and now more broadly diversity programs. I agree.
Nick, what's your take?
Yeah, let me pick up on that last piece that Fortney mentioned. Fortney, good summary of the case. One or two things just to step back even before this case that makes this just so fascinating for those of us who are interested in affirmative action, both in our professional lives, but also from a societal perspective, is go back to 2004, where the Supreme Court addressed the issue of the University of Michigan's affirmative action programs, both at the undergrad and at the law school level. And Justice Sandra Day O'Connor, no longer on the court, who was somewhere between moderate to right of center, she authored the majority of the opinion where she said, in certain circumstances, affirmative action in a university admission context is appropriate. But she said specifically in that, we look forward to the day where this will no longer be needed because our society doesn't need it. And she put a 25-year potential sunset on when this might be needed. Well, we are only 10 and 12 years into that 25-year period with the initial University of Texas case, and then this now off of the remand 2 years later. And it was really fascinating as it built up because Justice Scalia was still alive. He died after the oral arguments on this most recent case, but before the decision. So fascinating that we've seen the ground shift beneath our feet in terms of the Supreme Court and potentially the majority and the decision that emerges from this. Now, that said, to me, and guys, I'll ask you to weigh in, there are two critical takeaways here. The first having to do with university admissions and affirmative action. I feel like this has now been put to bed for a generation. It was interesting that this came up again so quickly after the O'Connor authored decision 10 and 12 years ago. I think there was maneuverings in such a way where a conservative movement around anti-affirmative action felt that they had a chance to reverse the decision that O'Connor had authored in the University of Michigan case. Ultimately, we now see that that is not the case, and decisively so, with Justice Kennedy flipping on this issue. Folks, Justice Kennedy has addressed, as a judge, both below the Supreme Court and at the Supreme Court, has addressed the issue of race-conscious decision-making many times, and literally every time he's done so. He has a long record, a written record of this. Every time until this decision last week, he has said, under no circumstances do I see as constitutional taking race consciousness into account. In essence, he had a change in position in this decision where he was the author of the majority opinion. So the bottom line is, and Dave, to your point about the 5-3 and trying to figure out the chess game of who would support this and who wouldn't, I do not think we will see the Supreme Court accept a college or university admissions case anytime in the foreseeable future. I'm talking about, my prediction is probably 10 years out. Remember that the Supreme Court need not take any case that is put before them. They elect to take these cases, and they do so to clarify areas that are uncertain. They have clarified with last week's opinion. You may see cases that come up on certiorari that they're offered to the Supreme Court in the foreseeable future around this issue. I think this is done now. Now, universities who are listening in here, this does not give you carte blanche to do anything you want with taking diversity or race into account. Justice Kennedy in his decision was very careful with his language that universities must look carefully at the balance of interests involved here. But in terms of the Supreme Court weighing in again, I think we're not going to see that for quite some time. What is the other significant implication of this? The bottom line is for employers, not much of anything. This is in the university admissions context, and the law that evolved around this, the case law, and to Fortney's good point about this being in a public university context, so there are constitutional implications. We in the private sector as employers do not operate under constitutional implications for our EEO and affirmative action programs. Rather, that's in the context traditionally of Title VII and other relevant non-discrimination laws. So there's no specific effect of this decision with respect to our government contractors and their mandated affirmative action programs or even their voluntary diversity programs. But it is more holistically, it is a significant decision because it shows where the Supreme Court is weighing in on the issue of affirmative action and race-conscious decision-making. They have once again thrown their support behind that.
I think that's right. I think that a couple of points. One, those that are in the business of diversity, this opinion is a must-read for you, even if it's not affirmative action diversity. There's very strong language embracing the importance of diversity, recognizing diversity. I think for diversity and inclusion programs, the majority opinion, Justice Kennedy has provided lots of ammunition to buttress and enhance the legitimate interest that D&I programs carry out. That's one. Number two, just to what Mickey and I both touched on, state university versus private, and most federal contractors outside the university context are private employers. That means that the standards they have to pass are more lenient. They're not, this is the most demanding. So the point being, if these sorts of programs and initiatives can survive judicial review under what's called strict scrutiny, which only applies to state actors, then the rest of the federal contracting community, non-state universities typically, their programs with that very high level of confidence under the executive order can proceed. And the possibility of a legal challenge now is, I'd say, almost zero.
So let me sure I understand this. So this case was, a public university, and the question was this a violation of the Equal Protection Clause of the Constitution?
Right.
That's because it was a state university. That would not apply to our contractors, right? Who, number one, are following 11246, which already makes it very clear that you can't take race, ethnicity, and or sex into account when making a personnel decision, a hire, a promotion, a termination, pay. The affirmative action plan in our context for contractors allows us to do a utilization analysis to see if there's an imbalance and then engage in good faith efforts. I think, gentlemen, what you're saying what will be interesting in a Title VII context is whether or not these D&I programs that kind of tiptoe on whether or not they are implementing some sort of quota, the Rooney Rule, that certain amount of minorities or females have to be on the slate. It'll be interesting to see whether that is challenged in the future. But I think, Mickey, to your point, for now, it's pretty settled that affirmative action in universities and probably under 11246 will be around for a while.
Right. And I think that with respect to things like Rooney Rule and other examples where diversity has been used to read race back into what ultimately are defended as neutral, Title VII neutral decisions, I think this decision, although not directly supporting that, is very, very helpful to justify those sorts of efforts.
Mickey, closing comments.
Well, this is a really momentous week and a momentous decision, and one that if you would have asked me just a couple of months ago, the direction this was going, I and many of the people, Fortney, perhaps you, others who are reading the tea leaves here and reading the people on the court, which is in flux now, would have expected us to go in another direction. So this is good news for those who advocate on behalf of affirmative action and D&I programs, not just in universities, but also in a corporate context. So good news for most of you who are listening in and watching in on this and wanting to find facts that can bolster your diversity and affirmative action programs.
Well, gentlemen, thank you so much. That was really helpful. And for those of you out there, we'll be talking more about this in November. We have our fall conference in Chicago. If you're interested in attending, once again, please go to our website, the OFCCPinstitute.org, to sign up for our 2-day conference. And you'll hear from our faculty, made up some of the top labor and employment lawyers, labor economists around the country. The 3 co-chairs will be there as well. And once again, if you're interested in membership, check out our website, call us, ask us questions, and we look forward to seeing you all in the future.
Great. Thanks, guys.
Thank you so much.